sort of, in retirement. And it sounds like it when I begin. I promise it was good once before.
It still is.
Having not heard it, you really think highly of me.
I'm imagining it.
All right, that's all for tonight. Thank you.
Thank you.
Is it live or not?
Yeah, we're live right now.
Oh, we are?
Actually,
Hi, welcome to Public Policy Show. Tonight we have Raphaëlle Soffe in studio, and we're going to welcome her.
welcome, Raphaëlle. Thank you so much for joining us. Could you please start out by telling us a bit about yourself and your academic background?
Sure. As you all know, my name's Raphaëlle. I'm from Wales in the UK. Originally, I'm a junior at Harvard College, and I have a variety of research interests that were really enhanced by my summer experience, something I can talk about later if you want. So I have independent research interests in antitrust, intellectual property law, and also econometrics, which is sort of a side thing on top of my degree in social studies. I've also had a variety of experiences dealing with government and legal institutions. So, for example, I've done placements with Clifford Chance, the Bar Council in London, Drystone Chambers, as well as working for multiple MPs and Governor Cuomo in New York. I have a variety of experiences, and I can't wait to talk about antitrust specifically, which I know you're both very passionate about.
Yes.
As well as my independent research interests in intellectual property, Hong Kong. I was there this summer. Fabulous experience. Ask away.
Yeah, so last spring you actually wrote a paper on antitrust, and it's called Reigning in the Digital Revolution in Antitrust We Trust. So can you tell us what made you interested in antitrust and what were your findings?
So I'd have to say it began with Vestager, the then president of the European Competition Commission, coming to Harvard Kennedy School for a forum. And she spoke with so much passion and dedication to upholding antitrust regulation in Europe that I suddenly sort of sat up in my seat and I was like, hold on, there is a fight to be fought here. There is a battle that's not yet won and problems that have not yet been solved. And I think one thing that stood out to me that she said was that these companies such as Google, Facebook, have become so large, so significant that they've almost displaced the role of the normal standard regulator in a market. It's the European Commission or even domestic sort of authorities such as the CMA in the UK have sort of had their role lost as a consequence of these big businesses, these big tech companies, almost like becoming the regulator in their own market. They have such a large share of the market. So that was something that really concerned me because I've always been in favor of competition. Something that I know you, Shota, have done fabulous thesis work on at the Harvard Kennedy School. Should definitely check it out if you have extra time or speak to him personally. And I just, from that point onwards, I was like, I'm going to write this article. I'm going to read into it more. And, one thing led to another. I got involved with a small startup called Children for America that is involved with providing antitrust advice to small businesses, almost a startup for startups. And, it's just really sort of spiraled from there.
Okay, I have to actually ask you a question about your interview with Diana Moss last spring as well, and then what was her experience going to the law school at the Harvard Law School Antitrust Association?
She was a formidable character. Thing is about Diana Moss is that not only is she, a very strong woman indeed, and she really knows her content, but she genuinely believes in what she's advocating for. I was, a sophomore, a little nervous. It was my first proper interview, being the interviewer, and she really, welcomed me and spoke to me afterwards about the deep complexities of antitrust and, how the youth of today can really begin to act as well. I know that she spoke wonderfully at the law school, and that she had a very high turnout for a reason. And I think if we are to look at antitrust in America, and you look to Diana Moss, you know that it's, at least its future has some safe hands on it.
Great, thank you.
Absolutely. So aside from interviewing Diana Moss and absolutely crushing it, you spent your summer in Hong Kong. That must have been an incredibly insightful experience. Would you mind sharing more about your summer experiences?
Sure. Where to begin? So I was in Hong Kong for a Harvard summer school program with a social studies department. I was working under Harvard faculty, so I was taking two classes, one on migration flows in East Asia and the other one on the history of US-China relations. But during the period of my studies and talking with these faculty members who are both from Harvard, the protests started to break out. The very first one people kind of forget about is the one that was about the 30th anniversary of the Tiananmen Square. And then the bill and protests linking to the extradition bill started to creep in. So I attended the protests. I made a habit of interviewing frontline protesters. I met with a non-permanent judge to the Court of Appeal of Hong Kong. He's a particularly interesting individual because he's non-permanent. He's from the UK. He was the Supreme Court president of the UK Supreme Court, and he had interesting views on how the bill was essentially filling in a legal loophole, but perhaps that Carrie Lam was a little misplaced in sort of the way that she approached the bill. So that was, sort of like a really insightful experience for me. And then I also wrote this paper, which I think I've mentioned to you previously, about how the history of US-China intellectual property is not always as it seems.
Yeah, I wanted to ask a question about that. So you wrote a paper on extraterritoriality, and just to define extraterritoriality for our viewers, it's basically when foreign companies go into China, they don't have to abide by local laws. They can only abide by their Western laws if they're Western companies. And that has been a problem with the Chinese government. So you write in your paper that it's been 4 decades of inaction. Why does China want to repeal this provision?
So sort of like explaining what exactly my paper was getting at, the very first copyright agreement between US and China was in 1903, the Treaty as to Commercial Affairs. And it was groundbreaking. It was the first time anything to do with intellectual property was put on paper and an agreement of sorts. Now, the issue with this treaty is that it was never really implemented, never really upheld. And the US has the tendency of pointing the finger and saying the Chinese never really abide by treaties. And the truth was there were genuine attempts by the Chinese government at the time, the Qing dynasty, to actually implement the provisions. And there were 4 years afterwards where you had multiple drafts, up to 3 drafts, that tried to implement the treaty. Now, the key problem for the Chinese was this extraterritoriality issue, where you were actually having Western merchants coming to China and saying, this treaty doesn't satisfy us. Why? Because it's Western merchants who are coming to China and violating the copyright laws. And China did not have the legal jurisdiction to prosecute foreigners acting illegally on their soil. That's what extraterritoriality specified. And the treaty, although requiring China to uphold these copyright regulations, also said they must uphold the principle of extraterritoriality. Now, at first, China was like, okay, fine. We will live with extraterritoriality. We know that the Japanese, just less than a decade earlier, had their extraterritoriality removed, but oh well, we know that we are sort of a little less developed in terms of our legal system, so we'll tolerate it. It was only when the merchants came forward that they decided to edit their view. And as soon as they mentioned the prospect of removing extraterritoriality, the US shut it down. The conversation almost completely shut down. There was another aspect where, can you imagine, there were about 3 or 4, if not more, different legal jurisdictions operating within China. You had the British, you had the Portuguese, you had the Americans, and so on and so forth. The Chinese judges didn't have a clue which legal system to look at. It was a very complicated mess. So yes, the Chinese legal system had its problems, it had its issues with corruption, had its issues with implementation, with precedent, and with some kind of cultural tendencies to perhaps favor more of family structures, like the local villages would have their own sort of mini legal system. But I look at these 4 decades of inaction as having been triggered by this 1903 treaty. It was the US's refusal to compromise on extraterritoriality that led to the Chinese sort of holding up their hands immediately and saying, well, we can't proceed with this. And then the US saying, well, we can't either. And then you have 2 world wars, you have several revolutions, and then you have governments coming and going, and copyright isn't exactly the priority of a country fighting for survival. So that's really what my paper was looking at, and I don't know, hopefully it will be publishable content soon.
Yeah, and then actually that applies with antitrust in China as well, because when you have extraterritoriality, if a Western company comes in, and here actually we're trying to promote small businesses in the US and trying to promote antitrust, but at the same time, these large companies that go into China are emboldened by this provision because they're not touched by the Chinese law. So they can expand their business share, they can expand their business market, and therefore undermine our efforts here in the US to promote small businesses because they're getting power and revenues from China in this case. So I'm going to go to Caroline, and she's going to ask you the next question on antitrust.
Yeah, just to clarify quickly, extraterritoriality was removed from China after World War II, but there are favoritism mechanisms in China still for European and US firms.
Exactly.
Which is, if you were going to put in a hierarchy where firms stand in China in terms of preference, government firms are at the top, Western firms, and then domestic private firms are at the bottom, which is something I can talk about another time. But, intellectual property is a concern for Western firms, and more China is tentative to that. It's domestic private industries now in China that are suffering.
Thank you for that. That was incredibly insightful. Hong Kong's Competition Commission recently launched a report anti-competitive conduct campaign. What insights can you provide, both through your summer experiences and your academic research, on this initiative?
Sure. So it's essentially an act of public policing. It's their first real attempt to bring the public on board in terms of identifying violations of intellectual property or antitrust specifically. They call it anti-competitive, so it can fall under a lot of different terms. So they're trying to bring the public on board, they're advertising. And this is something that's not new at all to advanced legal jurisdictions or mechanisms across the world. The US has similar mechanisms where they try and incentivize the whistleblower to come forward. And so does the EU and the UK. Even though there is a key difference between the US and the EU, and that's in terms of who they're incentivizing. So in the US, Department of Justice specifically offers sort of leniency to those who are culpable in cartels or in sort of violation, so that they're sort of stuck in the middle of it, to come forward, sort of spill the beans, so to speak, as we say in the UK, and then they'll get leniency. Now, that's great if you are culpable. If you're non-culpable and you happen to have spotted an antitrust violation, there are very few incentives involved. In fact, very few financial incentives that are sort of really embedded in people are aware of them. And also, there's a negative incentive that your privacy is not guaranteed. Mm-hmm. You've had cases of individuals coming out against companies like Google or Facebook, whistleblowing, but then not having their privacy protected. Now, the EU and the UK are very, very certain that privacy is completely prioritized. So whistleblowers feel more comfortable to come forward, and they also offer a positive incentive of financial rewards if you come forward and you're not culpable. You just happen to have spotted something. Now, what my article was really saying was that Hong Kong needs to be aware of these two systems, or at least it needs to decide pretty fast how it wishes to incentivize and who it wishes to incentivize. And I think I just really drew at the end of my article was that, Hong Kong is not a country. It's not the US, it's not the UK, even though it's had relationships with the UK in the past. So it does have the issue of mainland China, a completely different legal system. You have, China is in its adolescent stage of its antitrust reform. You've just had the new Shanghai financial courts that have just been set up. But, as I said, early stages, and it's primarily for Western firms. Hong Kong is a little bit more advanced in that way. question is, the basic law eventually has sort of like a time limit on it. And eventually, we're not completely sure how much control Beijing will exert over it. Protests at the moment are really touching upon that point of just how much influence will China have on, Hong Kong's small version of democratic principles, and then also on their legal system, which has remained largely untouched. And that's why you have a lot of British judges coming and sort of sitting in that Court of Appeal. It's because the law is so similar, precedent is so similar, and you really don't feel like you're in mainland China.
Mm-hmm.
So that was what I was talking about, was this Hong Kong is in a limbo. It's, on one hand, it has choice in how it promotes antitrust regulations, and in another perspective, it really doesn't have a long-term choice. And that's, that could be up for speculation, but that's definitely where my concern lies, is that how can one establish legal precedent when there's actually going to be a full stop on that precedent?
Mm-hmm.
Yeah, great job actually going into and exploring criminal aspect of antitrust in Hong Kong. And one of the things that actually Hong Kong antitrust authorities can learn from the US is also the difference between civil law and the criminal law, because criminal law in antitrust only penalizes, right? So they would provide like a punishment for a company and they have to pay $1 or $2 or $3 billion. But criminal cases they don't discourage them from future antitrust violations, and a lot of the businesses consider that as a cost of doing business. So if it's a civil case, then they have to change their behavior. So that's first. And second, actually, a lot of the industries now know that HHI is not effective because it doesn't take into account horizontal shareholding, as you know. So if that can be modified and applied to Hong Kong, then that would be excellent as well to enforce it.
That reminds me of a field trip I took to Dongguan. I went to a factory there, a toy factory, and I remember asking the general manager, about intellectual property. And interestingly, one of the things he said was that he really wanted to uphold intellectual property rights for his customers, who were primarily Western companies, but that the local government kept asking him, why do you need these patents? Why do you need to register this particular trademark? So he had this perception of that they were doing the best that they could. But if you'd seen their logo and the factory's logo, it looked an awfully lot like Pac-Man. But I wasn't to say anything.
I've never seen that before.
And I was only told afterwards by a venture capitalist in Shanghai that Dongguan is known as the intellectual property violator of China, which I definitely, was given the sugar-coated version when I went there. But I think Pac-Man sort of summed it up a little bit.
Yeah.
But yeah, sort of definitely there are issues for sure.
Well, thank you so much for joining us today.
No worries. It's been a pleasure.
And thank you for watching. Have a good night.
Good night.
Thank you.